Good afternoon. Welcome to our webinar today. Today we're going to be talking about a very interesting topic that is, evolving in the law on a daily basis, really. We're going to talk about challenging TCPA class action claims during the evolving legal era and the evolution of case law literally on a day-to-day basis. Today, I am your presenter. I'm Lisa Messner. I'm a partner with McMurray & Schuster, and I head the litigation team here as well. The bulk of my practice is class action defense, and of course, a lot of that defense is focused in the teleservices space in the defense of TCPA claims and TCPA class actions. And before we get into our content, I am an attorney, so I'd be remiss if I didn't give you the disclaimer that the information that we're going to talk about today is for informational purposes only. Anything that is discussed should not be construed as legal advice because every case is different, facts are different. And so in the event that you do need specific legal advice, I would encourage you to actually consult with an attorney to discuss the specific facts associated with your matter. So today, just giving you a little preview here with an agenda of what we are going to talk about today. So we're going to talk about the trends with TCPA class action filings that we're seeing over the past year, specifically in 2021. We're going to talk about the Rule 23 requirements, and specifically I'm going to be focusing on the Federal Rules of Civil Procedure. Rule 23 is the civil rule that governs class actions. We're going to talk a little bit about some new novel developments in the law that might be used to challenge class-based claims at the pleadings phase rather than the more traditional phase at class certification. I'm going to talk about some options as well for bifurcating and limiting discovery, and it ties a little bit into those challenges to the class claims at the pleadings phase, and we're talking a little bit about strategy in terms of how we can limit discovery burden associated with class claims. And then lastly, we're going to talk about the more traditional challenges that you see at the class certification phase and some new developments in the law that present some rather unique and novel arguments within the class certification phase. So let's start out by talking about trends and what we are seeing for filings in 2021. So our recent statistics are showing that through September 30, 2021, there were almost 1,400 TCPA filings nationwide. The exact number is 1,389 TCPA filings across the country. Importantly, almost half of these actions were filed as putative class actions, not as individual claims. And when we are looking at statutory damages under the TCPA ranging from $500 to $1,500 in liability, the liability very quickly becomes exponential and can easily approach the multi-million-dollar, bet the company kind of mark in terms of potential exposure. Another note that is not on the slide that I want to raise in terms of the statutory damages is the issue about the ancillary state laws that apply to telemarketing as well. And so you're not only looking at statutory damages under the TCPA, you're potentially looking at an additional statutory damage under a variety of different state laws that have additional sources of damage available for essentially telemarketing violations. And those include, just off the top of my head, Texas, South Carolina, and Illinois. And it's interesting because the states are starting to, in the post-Facebook era, codify more of these laws that are more robust and have additional requirements and additional damages available. So that's all to say that the statutory penalties can very quickly approach exposure in the multi-million-dollar arena. All right, so let's talk a little bit about Federal Rule of Civil Procedure 23. This is the rule that governs the requirements associated with a class action. And so there's essentially 4 requirements under the rule. It has to be, we look at numerosity, commonality, typicality, and adequacy. And the way that the rule defines those things is that for numerosity, the class is so numerous that joining members is impractical. Commonality looks at the commonality between law and facts that are common across the class. Typicality looks at the claims and defenses of the representative parties being typical as to the class. Significantly note there, it's not just the claims that would be typical, it would also be the defenses of the defendant that would be typical across the class. And adequacy is that the named plaintiff, the representative party or parties, will adequately protect the interest of the class. So the interesting thing about Federal Rule 23 is that traditionally that was the procedural mechanism that drove class certification motions. And those motions had, for a very long time, been filed after discovery had been completed, that the litigation had been on a track to go for a while. And Federal Rule 23 is interesting in that it is more increasingly being used to challenge class claims at the pleadings phase. And what that means is that you're challenging right out of the gate. As soon as a complaint is filed, at the time you file an answer or some kind of motion responding to the complaint, you would, in tandem with that, file a motion challenging the class claims. And it is important to note that the interpretation of Federal Rule 23, and in fact within Federal 20 Rule C, within the Rule 23C, there is an indication that the court should decide the class certification issue at an early time as practical. And there is nothing specifically in the rules that otherwise indicates that the court is somehow bound to wait on a motion for class certification to be filed. And so we are seeing courts increasingly permit motions to strike class claims at the pleadings phase. And we're seeing that within the 1st, 5th, 6th, and 7th circuits, particularly permitting these types of claims. And the way that we are procedurally seeing it is the interplay between Rule 12F, which allows the court to have the authority to strike allegations in a complaint, combined with the failure to meet those specific requirements within Rule 23 of your commonality, typicality, adequacy. And so you're using those things in tandem to challenge right out of the gate at the pleading stage. And it provides for some interesting ability to use some legal strategy up front by a defendant. And so just by way of example, for instance, in the Manning case, the district court held specifically that it had the authority under Federal Rule 12F to strike class claims right at the pleadings phase. We have the John versus National Security and Fire Casualty Company out of the 5th Circuit, which specifically said where it is facially apparent from the complaint that the class claims cannot be sustained, that striking them at the pleadings phase is warranted. We're seeing this same ruling within the Pilgrim case in the 6th Circuit. In that case, the courts have held that either a striking or dismissal of the class claims is warranted at the pleadings phase if there would be no amount of discovery that could cure the definition of the class. And then we're seeing just some evolving law within the Northern District of Illinois talking about failsafe classes, which we're going to get into a little bit more, and some other areas. So let's talk a little bit about challenging at the pleadings phase based on what is called a failsafe class definition. And so the failsafe class definition is essentially framed as a legal conclusion. It is indicating that class membership can only be determined by deciding the merits of the case. it precludes the possibility of an adverse judgment against class members, and that they either win or they're not in the class. And so courts look at this and determine that this type of fail-safe class definition that presupposes defendant's liability it's improper and inherently unfair to defendants. And so what we see is that some courts are divided in that they are determining that the fail-safe class definition is a premature inquiry at the pleadings phase. However, it is strategic for a couple of reasons to raise the fail-safe issue right at the outset, because it can preview for the court some deficiencies that might exist at class certification. It can give an opportunity for maybe you to limit or frame discovery to only certain levels of confirmatory discovery to see if the class could be redefined. But do understand that courts are split on the issue as to whether fail-safe class definitions is something to be decided at the pleadings phase or at the class certification phase. But we are seeing courts strike them at the pleadings phase, and this is one of the bases upon which they are doing it. So typicality. This is another challenge that can be presented at the pleadings phase to challenge class claims. And so we want to ask, do other members have the same or similar injury to the plaintiff? Is the action based on some kind of conduct that would not be that would not be unique to the named plaintiffs? Have other class members been injured by the same course of conduct? And so the keystone case from the United States Supreme Court that talks about typicality is the Walmart versus Dukes case. And in that case, the court really said typicality has to look to circumstances that are unique to the named plaintiff, which can threaten to become the focus of the litigation. And so where defendants can present significant unique defenses with respect to the classes as defined, challenges at the pleadings phase on typicality can be successful. So for example, what we would look at is the named plaintiff within the defined class? And so we are presently working on a case where the named plaintiff actually received a phone call at his mother's home, but he did not answer the phone call directly, and he answered the phone call directly, but he was not the subscriber to the phone. And so that may present an individualized inquiry. Another example might be whether in a case where a class is defined to include a broad scope of persons within a specific state. And if those persons may be subject to an established business relationship with the defendant, then that can present another type of individualized inquiry where the court necessarily has to examine the class on an individual basis, which then takes it outside of that typicality requirement of Rule 23. So those are the types of challenges which, again, can be presented at the pleadings phase, and particularly where discovery would not necessarily cure the way that the class is defined or cure those defects, then courts do have the authority to strike those allegations at the pleadings phase. And then another challenge that we're seeing at the pleadings phase, which presents kind of an interesting argument, and it's not on my slide, is challenges to a request for injunctive relief under the TCPA. So we very typically see in TCPA class actions that there is a specific request for injunctive relief, and that is authorized under Rule 23B2 to seek this type of injunctive relief across the class. But the difference is that as related to TCPA, we're talking about statutory damages. So courts are holding that at the pleadings phase, this request for a broad brushstroke of injunctive relief across the class is not warranted under Rule 23B because of the interplay with the statutory damages. And so we've seen a recent case out of the Southern District of Ohio hold this. We've seen this within the Sixth Circuit and with other circuits where courts are specifically looking at that injunction request and striking it. And that is another significant component to damages, because we have heard attorneys within the plaintiffs space and within the experts related to the TCPA talk about how injunctive relief in terms of monetary value can in and of itself be millions of dollars because of the restrictions on business practices. And so that is another significant a strategy for looking at challenging class claims at the pleadings phase. And so if you're going to go down the route of seeking to challenge at the pleadings phase, one of the principal arguments is going to be that if the class claims are legally deficient, if they cannot survive some type of motion to dismiss or strike, and they on their face can't meet the requirements of Rule 23, then the burden associated with class-based discovery is not warranted. It's not proportional to the needs of the case. And so you have to be thoughtful in thinking about when you want a request of the court to bifurcate discovery. If the intent is to challenge the claims at the pleadings phase, and that would include a challenge on jurisdiction, which we're not talking about today, but any kind of challenge to the claims at the pleadings phase, you're going to want to get right in front of the court the issue of bifurcation of discovery right out of the gate. You're not going to want to wait. You're going to want to put that right in your case planning meeting. You're going to want to tee that up for the court as early as you can. And the argument is just simply that if the complaint on its face cannot meet the Rule 23 requirements and it cannot state a valid class claim, then the scope and burden of class-based discovery is not proportional to the needs of the case. And you can attack it in a couple of different ways. You can come at it from proportionality. You can come at it from undue burden. That is essentially the argument. And what we do increasingly is raise it with the court at as an early possible time as you can in an effort to try to limit those burdens of discovery while the court is sorting out what class claims may survive and may not. So the benefits of challenging the class claims at the pleadings phase, and do understand we're talking about how courts are split in their decisions on this, right? So not every court is going to agree with you that there shouldn't be some degree of discovery or that the plaintiff shouldn't be permitted to amend, but there's still strategic reasons to filing a challenge to the class claims pre-discovery. So the first one obviously being, if you prevail, the class certification fight ends before it's ever even been gone. The second one we just talked about in terms of having a possibility of discovery either limited or narrowed or bifurcated, any way in which we can limit that burden of class-based discovery in scope or in total, you want to always be doing that and thinking about that from a defense perspective. And then another point is to think about even an unsuccessful motion gives the court a preview of deficiencies within the class claims. And it specifically highlights which portions of Rule 23 may or may not be met. And that is a very interesting way and a very thoughtful way to help educate and preview for the judge what might be deficiencies coming down the pipeline for a more fulsome class certification motion. And then lastly, this is also not on the slide, but even an unsuccessful motion may also preview for plaintiff's counsel some deficiencies potentially within his or her own case. And then understanding the strengths and weaknesses of a case at the outset then oftentimes assist our clients in achieving early resolution at a more reasonable rate of these types of TCPA class actions. So we've talked about challenging class certification at the pleadings phase. We've talked about ways to strategically try to limit discovery or bring about resolution of the case early. And so now let's talk about what if those things do not work. Or what if from a defense standpoint, you decide that not to pursue an early challenge to class claims, whether that be based on your jurisdiction or some other strategic decision. What are some things you can think about for challenging class certification? And so the strategy for class certification has to start with discovery in identifying where those challenges are and identifying the discovery you need from plaintiff to focus in on why he or she does not meet Rule 23 requirements. But some tips for challenging class certification. Again, we want to come back to individualized inquiries. Are the classes defined in a way such that the court must make individualized inquiries as to persons within the class, such that it takes them outside of that commonality requirement? Examples of that may include if persons may have an established business relationship with the defendant. So that's just one example. Other ones might be whether consent was actually provided or not provided in the context of for instance, a pre-recorded message call. Another thing to think about is unique defenses. Are there unique defenses to the named plaintiff or plaintiffs that are present that seek to threaten to become the focus of the litigation? And if that is the case, then you will want to fully develop what those unique defenses are. So for example, if your named plaintiff has an established business relationship with the defendant, that might take it outside of the purview of how the classes are defined. Are there some type of consent issues that might take your named plaintiff outside of the class? Is there an issue for the example that I provided where someone answered the phone at their mother's house, but they're not the subscriber to the telephone number? Is there some kind of unique defense like that that you can latch onto and explain why it takes it outside of where this plaintiff, it kind of combines typicality and adequacy, because if a unique defense to the named plaintiffs or plaintiffs focus to become the threat of litigation, then that is harmful. Courts have determined that is harmful to the class as a whole. We talked a little bit about named plaintiff not being within the classes as defined, and it ties into unique defenses as well. And so if the class is defined in a way to capture a scope of persons that the named plaintiff does not fit within, then you also have that type of typicality adequacy challenge you can look at. And just make sure that in discovery, as you're going through, you're fully developing these things on the on the record through deposing the plaintiff or named plaintiffs, and through identifying these types of issues, whether it be through subpoenaing phone records and so on and so forth. But you want to make sure you have a very fulsome record as to that point. And then we want to talk a little bit about adequacy. And I will say that traditionally, it's not been the strongest argument to be able to raise in challenging class certification. We do have this recent case out of Southern District of Florida, Johansson versus Blue Green Vacation. It's an interesting ruling because in that case, the court looked specifically at the plaintiff's conduct. And in connection with the case, the plaintiff admitted in his deposition that he had actively engaged the telemarketer, feigned interest in the vacation services being offered, went through the process of providing an alias essentially and personal information, and went through the whole process with them on multiple occasions. And he readily admitted it. He says that the court held was that the plaintiff lacked typicality because the plaintiff's claims differ from those of the putative class members' claims, and specifically the record clearly established that he had used deceptive and dishonest tactics to establish his claim. Therefore, the plaintiff's claim is inherently different from those of the putative class members who presumably did not use similar deceitful methods and who did not want to receive telephone calls. And so this is a very interesting ruling in that, the court really looked and focused in on the conduct of the plaintiff here. And so how can we use this case? We can use it by analogy in a lot of very similar cases. Not only this plaintiff, but in multiple instances, we see allegations in a complaint that the plaintiff or the named plaintiffs have engaged the telemarketers to identify who they were, have signed up for the products and services, and have done so on multiple occasions. And we're seeing that under the guise of plaintiff's contention that he or she is investigating the source of the call, that comes to be. But oftentimes we do see allegations at the pleadings phase and admissions and depositions from plaintiffs that probably spill over into what the court is talking about in this Johansson ruling in terms of the conduct being somewhat deceitful, in that the plaintiff is engaging the telemarketer, they're feigning interest in the services, they're signing up for them, they're providing personal information or aliases to be able to try to track this telemarketer. And so I think going forward, we will see some ability to use this ruling to move to strike at the pleadings phase if you see those allegations within the complaint, and then even to use it at class certification if you can get some good admissions from the plaintiff during the deposition to the effect that there has been engagement of the telemarketer, they signed up for products or services, feigned interest, and I think that we will see some development for the defense bar being able to craft an argument that this type of conduct does really raise typicality and adequacy issues in terms of those named plaintiffs being typical of persons who do not want to receive illegal telemarketing calls, and also tying into adequacy in terms of being honest and forthright. And so I think going forward, we'll really see some creative uses of this ruling, and it's an interesting read. So I definitely encourage you to read the case. And so with that being said, that concludes my presentation today. And I thank you very much for joining us. And if ever you have any questions about any of the content that I talked about today, my email is on the screen, and you can feel free to reach out to me. Thank you so much.